that the state has made the decision to waive the habitual. If we were proceeding on the habitual, you know what your minimum is?
Right.
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual. All right, Mr. Saldana, you're here for a plea deadline date. So did you have a chance to internalize what I was telling you?
Yes, ma'am.
All right, so do you wish to have a jury trial?
Yes, ma'am.
All right, Ms. Ferguson, state, are you all going to be proceeding on the possession 1 to 4 or the injury to child?
The injury.
All right, so how long is this trial? How long will this trial take? All right, so Ms. Ferguson, if we could set this for a jury trial first thing.
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Saldana.
Mhm.
Your Honor, I have some time this afternoon. Would it be possible for Mr. Saldana to and I to confer just a little bit longer?
Sure.
We'll get the jury trial date, but just to make sure that we are all on the same page, as it were.
Okay, sure, most definitely.
I appreciate it, Judge. Thank you.
All right.
Your Honor, can I speak on the record?
What do you want to say?
I would like to object to the indictment and the evidence they're using for the indictment. And I'm also reserving all my rights.
Mr. Saldana, why are we talking?
All right, so let me explain something to you, Mr. Saldana. I understand what you're saying. I'm internalizing what you're saying,
Yes, ma'am.
but this is what I'm going to say, and I want you to internalize what I'm saying.
Yes, ma'am.
If you need open heart surgery, are you following me with this scenario?
Yes, ma'am.
And the doctor tells you, hey, you need open heart surgery, and I'm going to do the open heart surgery. Do you go to the library, read a book, and tell the doctor, hey, I know you're doing open heart surgery on me, and this is the scalpel you should be using, and this is the stitch you should be using, and this is the way you should perform that surgery?
No, ma'am.
See, and people think that attorneys just talk, oh, I can do that. All they're doing is talking, but behind their talking comes a lot of knowledge and a lot of experience. And everybody thinks that they can do that. So for example, with regards to an objection to the indictment or objection to the evidence used for the indictment, that's something that your attorney will be taking care of if legally there's a reason for it to be. If he determines that legally there's no grounds for it, then he's not going to go forward with it. That's the way it works. So your attorney wants to have a chance to talk with you. I'll let you speak with him in the box. And what date, Ms. Ferguson? All right. Your jury trial is going to be July 2nd. If you want to do something with this case, you can do something with it today, or either what's going to happen is you're going to be set for jury trial on July 2nd.
Yes, ma'am.
And I'm sorry, Your Honor, just for advanced information, I have a conflict on the 3rd. I'm a prosecutor for a local municipality, and we
Okay.
have court on the 3rd.
Oh, we'll work around it.
Thank you, Judge.
You're welcome. All right, so just have a seat in the box, but your jury trial date is going to be July 2nd.
Yes, ma'am.
All right, court is calling 2024 CR 2324, State of Texas versus Valentin Saldana. Could I have parties announced for the record for the state?
Marjorie Hillmore for the state.
Defense?
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Saldana.
Are you Mr. Saldana? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Saldana, did you review the document entitled True Bill of Indictment with your attorney, and did you understand it?
No.
All right, you need to speak up.
No.
All right, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the habitual, the enhancement paragraph, and we're proceeding on the underlying offense.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
All right, you're moving very slow with your answers. All right, do I need to speak up for you?
I think everybody can hear me pretty clearly. Yes, ma'am.
All right. I'm sorry, what?
Yes, ma'am.
Are you understanding everything?
Yes, ma'am.
All right. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
No, ma'am.
All right, do you want to go to a jury trial?
If I'm not satisfied with the way I'm being represented, no, ma'am, I don't want to go to trial.
All right. All right, so this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you, this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding of the habitual, you know what your minimum is?
Ma'am.
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm live. Yes, ma'am, I'm live.
What does that mean?
All right.
All right, we're back on the record. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There are no applications. The state is taking in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
No.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contents.
State, any evidence?
Your Honor, the state offers State's Exhibit number 1 and all attachments.
Any objection?
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Saldana presents himself before you, accepting responsibility for the matter before you. As the court may be aware in reviewing his record.
Excuse me, just 1 second. Mr. Cox? Mr. Cox? If y'all can move down to the other end, we're on the record. That's okay. All right, we're back on the record. Yes.
Thank you, Your Honor. As the court is aware, Mr. Saldana is currently on parole on a previous case. He would respectfully request, and I make this request on his behalf, that although we understand and he understands not binding, we would ask that the sentence that will be imposed today by this honorable court run concurrently with whatever actions parole takes on his former case.
All right, and what are the parole case numbers?
Your Honor, Mr. Saldana. If I may have a moment, Your Honor.
Sure.
Thank you. The burglary of habitation, Your Honor, case out of the 226 District Court, case number 2014 CR 10282B as in boy.
Mhm.
Yes, Your Honor, that's the open parole matter that, again, Mr. Saldana is aware it's not binding, but he would respectfully request this court make a notation that it's the court's desire that it run concurrent.
All right, this court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. This will run concurrent with 2014 CR 10282B. Take in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence. There's to be no contact with Mallory, Malerie, Saldana, Jaden Saldana, Jayden, and Irene Portelis. Is there anything else with regards to sentencing from either side?
Nothing from the state, Your Honor.
Not on behalf of Mr. Saldana, Your Honor, we appreciate the courtesy extended by the court and the state in allowing us to address this matter this afternoon.
All right. And then did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Those documents go to the defense attorney. Thank you. All right, we can go off the record. Your minimum is 25 years in the prison. You understand? Your attorney was able to get you less than the 25 years. Do you understand?
Mhm.
And I don't know what you don't understand. It appears that prison is not teaching you what it should be teaching you. But if you come back out and you commit another offense or alleged to have committed another offense, potentially based upon whatever offense that may be, you're looking at a minimum of 25 years. Do you understand?
Mm.
All right, good luck to you.
Thank you, Your Honor.
Thank you.
On behalf of Mr. Saldana, thank you.
All right, thank you. Joe Hernandez? Yes.
All right, Judge, he's on his way up. For your edification, this was a plea that we entered in front of Judge Angelini for 10 deferred.
Oh, no, I remember.
Okay, well, I'm just going to fill you in on what's going on there today.
All right, what's happening today?
So I asked the DA if he would be willing to consider the 10 deferred. He said, let me think about it. We did enter the plea fully and officially on the 4 silent. Mr. Hernandez then tells me he wants me to put in a motion to dismiss for prejudice, and I told him there is no such thing because, you know, judges bust plea bargains all the time. That doesn't give you a right to dismiss. And so then he says, well, he wants a jury trial. And I said, well, we have entered the plea on the 4 silent, so the judge may or may not allow you to withdraw your plea. And then that's what he wants to speak to you about.
All right. All right, we can go on the record.
Yes, ma'am. I just didn't understand what I was signing and.
Excuse
She
me.
hasn't
I'm
started
sorry,
yet.
I'm sorry.
All right, and let me stop you right there. All this thing where people say they don't understand what they were signing, based upon what is the information that I've received, that first it was 10 years deferred and the judge denied it. and then it came back to a silent offer, yeah, everybody understood. Court is calling 2023 CR 10221, State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Suzanne Kramer.
All right, and are you Mr. Hernandez?
Yes, ma'am.
All right, a plea was entered in this case on, let me see what date is stamped on here, on April 22nd, 2024. According to the plea bargain agreement, punishments to be assessed at 4 years in the prison. There's a $1,500 fine, and the state is silent on the defendant's application. All right, with regards to the plea bargain agreement, the court, of course, does not have the PSI because we're coming back. Can someone tell me what his criminal history is?
Judge, I don't have a file on that.
Basically, I could be off on this, but my memory is some minor misdemeanors and no felony convictions.
Mhm.
Mm-hmm.
That appears to be correct, Judge.
All right. So counsel, do you wish to have a PSI done, or do you wish the court to make its ruling?
Honestly, Judge, based on his criminal history, and of course, you don't have the benefit of the interview with him, but Mr. Delgado and Escobar and I can fill you in on part of the, I think it was part of this plea bargain too, was evaluation for Mick. There are definitely some mental health issues going on. You can tell by reading the report, but you do not have the benefit of having that in front of you. But I do feel confident, of course, it's up to him, to go forward today.
All right. So I am reading the police report. And based upon the police report that I've read that are in the stipulation, there is documentation of bizarre behavior. And I don't know, based upon the police report, if that bizarre behavior was drug induced or if there's some sort of mental health issues.
Which is why I think we had dual, right, with Mick, or was it just Mick?
I'm making that, yes, that was.
I mean, based on my time, and certainly I'm not an expert in any way, but I would tend to think it might have been both, but definitely some mental health issues.
All right, Mr. Hernandez, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Joe Hernandez.
All right, so Mr. Hernandez, have you ever been diagnosed with any type of mental health issues?
No, ma'am.
All right, not even in your childhood?
No, ma'am.
Drug use?
No, ma'am.
You're telling me you never used any drugs?
No. I'm an alcoholic, yes. I drink, but that's it.
All right, so in the stipulation, they're saying that you were exhibiting bizarre behavior.
Somebody was trying to take my life that night, and I was just trying to save my life. I was asking for help. And I didn't want to die that night. Somebody came at my door trying to kill me.
And
I ended up at the hospital. I called the cops. She has the phone record that I called the cops asking for help. I ended up at the hotel. I did everything wrong, yes, but I was just trying to save my life that night. I didn't want to die that night. I didn't want somebody to take my life for no reason. That's the God's honest truth. And I'm here fighting this. I don't have mental issues.
Oh, I mean, if you want a jury trial, we'll give you a jury trial.
I'm 34 years old.
No, if you want a jury trial, you can have a jury trial. That's your question.
Or you can request the judge to give you deferred, and then that way you know that, you know what the end result's gonna be.
I have a right to face my accuser, Your Honor.
No, here's the thing. And this is what I don't think people understand. We can go off the record. Everybody thinks that they can be an attorney without a license. They want to throw around magic words like Jack and the Beanstalk. Oh, let me throw right to accuser, right to confront. Let me throw, I want a dismissal. The question is, do you want a jury trial? Yes or no? And let me explain something to you. If you say you want a jury trial, this train is going to a jury trial. This train is not at the last minute. Oh, I see witnesses walking in the door, so therefore I'm deciding to enter a plea bargain agreement. If you want a jury trial, Court will give you a jury trial. You will get a quick, fast jury trial. So you want to discuss that with your attorney? You can. You all want to discuss that?
I'm good with the jury trial.
Do you want to discuss that with your client?
I think based on my conversation with him earlier this morning that he is, because of what happened the other day, it just took him off of pleading and he wants his jury trial.
All right, we're coming back on June 3rd
Thank you, Judge.
and you will have your jury trial and your plea deadline date has expired.
Thank you, Judge.
You're welcome.
May I approach, Your Honor?
All right, we're going to go on the record. Court is calling 2023 CR 5802, State of Texas versus Philip Diller. Can I have parties announced for the record for the state?
That done for the state, Your Honor.
Defense?
Alex Sharp and Mr. Dillard, ready?
All right, and are you Mr. Diller?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Diller, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Off the record for a moment. Counsel in the box. Excuse me, sir, in the box. If you will speak with the deputy, they'll move you down to that end. All right, we're back on the record. Mr. Diller, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on the lesser included injury to a child.
Any objection?
No objection.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of injury to a child, bodily injury intentionally and knowingly? That's a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Diller, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of injury to a child. They're recommending deferred adjudication and there's to be no contact with the complainant. Did you understand that to
Yes,
be
Your
the
Honor.
plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State offers states 1 and attachments.
Any objection?
No objection.
All right. And state, is the complainant aware of this agreement?
They are, Your Honor.
All right. You may continue to
Thank you,
confirm.
Judge.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, we're back on the record. The court has considered states exhibits 1 and attachments, which includes the stipulations. Is there any other evidence either side wish to present to the court before the court makes a ruling on sufficiency of the evidence?
Yes, Judge, Mr. Diller would like to make a brief statement.
All right, yes, Mr. Diller.
Yes, Your Honor, I grabbed her arm.
All right, and I'm assuming the grabbing of the arm caused pain. Is that correct?
Yes.
All right, is that yes?
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this is life-changing incident. Mr. Diller also suffered from a very debilitating accident in 2019. Prior to the outcry, before the charges were filed, he's in a great relationship, and he's been frozen in fear about fighting this case, and he would do it if he had to. This plea agreement, we believe, is in the interest of all the parties. Mr. Diller will not have contact with the complainant in the future.
Okay. Are you employed?
No, Your Honor.
So how do you support yourself? Are you on SSI or something?
I filed for I got denied for the original one because I have too many resources available to me because of my wife's income. Now they're doing the disability part of it, and I think they're at 95% right now.
All right. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with the complainant. Proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Regular random UAs. And due to your medical, are you on any type of medications?
Yes, Your Honor.
All right, you'll need to let probation know what those medications are, and you'll need to do a release from your doctor so they can make sure that those medications are being taken as prescribed. You understand? Bill visits 1 time per month for 3 months, and then at probation's discretion. $100 hours of community service restitution. If you would like, you can pay those off at $7.25 per hour. I always recommend the food bank because they always need help. But if there's another charity you would like to donate that to, just ask probation and they'll let you know if it's an approved charity.
Yes, Your Honor.
All right. Probation, and we'll do anger management. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, Your Honor.
All right, I understand that you have some medical issues that may preclude you from employment. The court costs in this case is probably going to be around $385 to $400. So if there's a reason why you cannot pay that, just let probation know, and they'll have to do an indigency form for you to see if that's true and if it would be appropriate for that to be waived. Do you understand?
Yes, Your Honor.
Do you have any questions about anything?
No.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back to court. All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, court is calling 2023 CR 2715W, State of Texas versus Ernest Diaz Jr. Can I have parties announced for the record for the state
State.
defense?
Greg Gameray for Mr. Diaz.
And are you Mr. Diaz?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Ernest Diaz Jr. who was placed on community supervision in 2023 CR 2715W for the offense of continuous violence against the family on March 27, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 39. On or about the third day of April 2024 in Garrett County, Texas, the defendant, Ernest Diaz Jr., did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department's duly diagnosed residential facility, in that the defendant was unsuccessfully discharged due to disregard of facility rules in violation of condition number 39.
How do you plead to that? True or not true?
True.
Your Honor, we'd waive the other violation.
Objection.
All right, did you understand by pleading true to violation of condition 39, court could find it true, grant the motion, sentence you up to 2 years in the prison and up to a $1,500 fine?
Understand. Yes.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes.
Court will find 39 true. Is there a proposed agreement?
Your Honor, we are asking that the court grant the motion, revoke the defendant's probation and sentence to 2 years.
That is our agreement, Judge.
All right, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Want to take care of this today? Yes. It's a little nervous, Judge, but we
No
talked
problem.
about it.
There's no need to be nervous, okay?
Mhm.
I'm just trying to make sure that I do what is best for you and also best for the community. So, probation. Oh, if you could speak up so the court reporter can hear. What is probation's recommendation?
Judge, at this point, it's revocation.
All right. And so, Mr. Diaz, there is no other program or any other placement that's available for you. So I'm going to grant the motion and I'm going to follow your agreement. I'm going to sentence you to 2 years in the prison, give you credit for any time served. There's to be no contact with the complainant. And this wasn't a family violence case, was it?
It was continuous family violence, but I wasn't the original.
All right, thank you. And there's an affirmative finding of family violence. And I'll request mental health for him at the prison, mental health therapeutic community. Whether or not you're placed in that will be up to them. I have no jurisdiction to force them to do that, okay? You still have to ask for it, you understand? All right, is there anything else with regards to sentencing?
Nothing from the defense.
Nothing from state.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. When you're released from TDC, if you can't find someone to help you with your mental health treatment, you can always come back to court. If I'm here, I'll try to direct you, okay?
All right.
But when you're released, it's best for you to go to Center for Healthcare Services, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're